Hi, my name is Brendan Olson, and welcome to the second episode of Law Talk. In this episode, I will give an overview of the case of Hamilton Health Sciences Corporation v. DH, which took place at the Ontario Court of Justice. To start, Hamilton Health Services Corporation v. DH is a case involving JJ, an 11-year-old girl diagnosed with acute lymphoblastic leukemia. Her doctors in charge of her care started her on chemotherapy and estimated this treatment would have a 90 to 95% chance of curing her of the cancer. JJ was in pain from not only the cancer but also the chemo treatment, and therefore her mother DH decided to remove her from the chemo treatment to seek traditional Aboriginal medicine in Florida. Her doctors had never seen evidence of someone surviving such a disease without chemotherapy, and therefore felt JJ would not survive if she would be removed from the treatment. It was up to DH to make decisions based on the best interests of her child, as JJ was deemed not capable of making an informed decision based on the fact that she had very little independence in answering questions and looked to her mom for everything, even stating that she lacks maturity, even for a typical child her age. DH challenged this, but the court sided with the hospital and their assessment. The doctors felt DH was under a lot of stress, wasn't making a decision that was in the best interest of JJ, and therefore felt she was a child in need of protection. JJ's medical care team admits that DH was a caring mother and wanted the best for her daughter. This was not in question. There was also evidence that she did want to pursue traditional medicine to alleviate her daughter's pain and cure her of her illness, and that it was their belief that this would work. Due to this, they claim that they are protected under Section 35 of the Charter of Rights and Freedoms, which states that the existing Aboriginal and treaty rights of the original peoples of Canada are hereby reorganized and affirmed, and should therefore be able to exercise their right to traditional medicine. It is also essential to know that Section 35 of the Charter sits outside the regular 34 Charter rights. It is not subject to Section 1, the Reasonable Limits Clause, nor the Notwithstanding Clause under Section 33. What was in question was whether traditional medicine was an Aboriginal right protected by Section 35. To prove this, they had to show that this practice and tradition took place before colonization, continues today, and is integral to their culture, meaning that without it, their culture would be significantly affected. Based on a creation story, it was proved that this practice took place before settler contact. Evidence was also shown that in their community, there were doctors who practiced traditional medicine, and JJ had been receiving this form of treatment prior. As well, showed that traditional medicine was used in traditional ceremonies and spiritual practices, showing it was deeply ingrained in their culture. Because of this evidence, and the fact that DH is committed to practicing her culture, the court decided that JJ was not a child in need of protection, and that DH is acting in what she feels is the best interest of her child, which is to practice traditional medicine, as is their charter right. On an individual level, this case plays a significant role in individuals seeking the care they want and not being forced in a treatment that is against their wishes. For JJ, the care that was in her best interest was to seek traditional medicine, but this was against the view of her healthcare providers, as they felt this would bring her significant harm and likely death. However, the best interest standard isn't about what is right or wrong. It is simply what the patient wishes based on informed decision-making while in a stable state of mind. The courts expect healthcare providers to respect these decisions and act in good faith, even if a substitute decision-maker expresses these views. This gives individuals seeking care peace of mind, knowing they won't be forced to experience a treatment against their wishes. Everyone has different beliefs, and despite these differences, everyone should be treated the same under the law, as affirmed under Section 15 of the Charter. This gives everyone personal autonomy and allows them to live how they wish, even if they aren't making the right decision. As a healthcare system, this case played a significant role in shaping how the system views the rights of the Indigenous people and helps to protect their culture as a whole. In the past, the rights of the Indigenous community were stripped from them, and in many cases, this still is happening to this day. When we look at residential schools created by our government, they were used to strip these children of their culture and force them into settler society. By not allowing this community to practice traditional medicine, we are essentially stripping them of their culture, just as the residential schools did. The government has admitted that these schools were highly damaging to their people, and the healthcare system as a whole needed to acknowledge the role it can play in reconciliation, such as the case of Hamilton Health Services VDH has forced them to do so. Thank you for watching.